So effectively, I've been asked to just give a brief introduction and an overview of the three laws that we have been working on over the past months. It has been a very exciting period for us because we dedicated quite a bit of effort in conjunction with the MFSA, with Honourable sort of Scambry's team, who was sort of really leading it, and his team, which really spent endless hours sort of working on this project, and obviously with the full support of the Prime Minister as well. So it was a really exciting journey. And effectively the plan and the project relates to three laws, right? So we have a new Digital Innovation Authority, and Mr. McCarthy here, who's the new CEO, will have a very exciting job to build it from scratch. And again, the concept of the new authority, just to latch on to what Gregory was saying, came about because of the broad uses of blockchain technology, and it was not thought fit to slot this particular framework under any existing competent authority in Malta, be it the MFSA or the MCA or any other competent authority. And the plan and the direction has always been, we want a focused new authority that pretty much can dedicate time and effort to creating a framework for this new technology, and work very closely with the other competent authorities in Malta insofar as this technology is applied by operators that are supervised by these competent authorities. The second legislation, which is the one which created the framework for technology arrangements and the related service providers, is the ITAS, the Innovative Technology Arrangements and Services Act. Again, this law will fall under the responsibility of the new MDIA. Thirdly, we have the third law, which is the Virtual Financial Assets Act. Again, this project was pretty much driven by the MFSA. Again, fantastic team. They really worked endless hours and very hard, and consulted extensively with stakeholders in order to make sure that we tackle all the particularities of this sector, and we come up with a regime which is as robust and comprehensive as possible. The ITAS effectively pretty much deals with a voluntary regime. Again, there was a lot of debate and discussion whether this regime ought to be mandatory or voluntary. In reality, we all knew that there were a number of operators based in Malta in this sector who may or may not feel the need to seek certification of their technology, of their blockchain technology arrangements in Malta by the MDIA. And as a result, after, again, extensive consultation, and here I would like to also thank all the other competent authorities who were part of the sort of discussion team, who are very forthcoming and open to discuss the way this new competent authority will work, the way in which this new law will be handled by the MDIA, and how the interaction between the MDIA and the various competent authorities will work in practice. There was extensive consultation, both public and private, with local and international operators, in order to make sure that as much as possible we tackle all aspects of this new initiative. So in this particular case, the ITAS is very much a voluntary regime. It covers a certification process for blockchain technology, effectively, where the person, the founder, the creator of any blockchain technology will be able to go to the MDIA and seek a stamp of approval, a certification indicating that this particular technology includes and specifies and caters for particular qualities, and that these qualities are there and are pretty much working as they should be. Then there was also the framework for the service providers through this technology arrangement. And again, after extensive discussion, two main service providers were identified, which are the technical administrator, which is pretty much entrusted with the corporate governance and the management of the technology arrangement, and finally the systems auditor. The systems auditor's role is probably going to be the one which is going to hit quite a number of different competent authorities, to the extent that the licensees supervised by these competent authorities are using blockchain technology in their operations. And the systems auditor is pretty much, again, going to be subject to a voluntary to a voluntary registration regime. The third law, which is the Virtual Financial Assets Act, is probably the one which is attracting most attention. Again, this is the law which covers the famous ICOs, right, which are the offering of coins or tokens to the public or to a select group of high net worth or institutional clients. And the plan in the VFA is pretty much to create a disclosure framework in order to make sure that prospective purchasers of these coins or tokens will effectively be clearly notified and informed of the characteristics of these coins. And again, here the MFSA has already published the list of information that must be included in the so-called white paper, which must be given to investors before they commit to invest in these coins or tokens. Then, apart from that, this law also covers what we refer to as VFA service providers. So any person operating an exchange, any person operating a market-making business, a brokerage business, a wealth management business, which is dealing in virtual financial assets, will again be subject to regulation on a mandatory basis under this Virtual Financial Assets Act. This law will fall under the responsibility of the MFSA as the competent authority, because it is very much an investor protection-driven piece of legislation. And again, given that we are talking about products which are very similar, even though with their particular qualities to investments, obviously having the MFSA as the competent authority is really the way to go. Here we are pretty much a cut above the rest of other member states in the EU, because we are the first state who has come up with a very comprehensive, dedicated framework dealing with this particular asset class. And again, I believe extensively in the first mover advantage, and we are definitely first movers within the EU, but also in a wider context. So effectively, if you are operating an exchange dealing in virtual financial assets, or you're safekeeping these virtual financial assets in the so-called wallets, or if you're managing a portfolio of virtual financial assets, or recommending any investor to buy or sell a virtual financial asset, all these activities will be subject to supervision under this new law. And I can tell you, I've only been in this industry for a little under 20 years, and in private practice for a little over 11 years. And I have never, ever seen the level of interest that we are getting since we obviously informed the community that Malta is obviously coming up with this initiative. Malta is really being placed at the forefront in this particular sector, and hopefully when the European peers will catch up, when the EU will catch up, we will have quite a few years of experience having dealt with this particular sector. So my final note are these three pieces of legislation perfect? Definitely not. Are they a fantastic product? Definitely yes. Obviously, there is clear the willingness from Honourable Chambry and from the MFSA, and I'm sure from the MDIA, to improve and learn as we go along. And this is really what we are sort of very much excited about. We will definitely learn, the more operators will come to Malta, they will bring knowledge to the island, we will all learn, the regulators, the operators, the advisors, and we will improve as we go along. There is a clear willingness to improve, and I am sure that we have a really bright future in this particular sector. Thank you very much.